If you have a DUI in Mississippi, you've been charged with DUI, or you got convicted of a DUI, how long is that going to stay on your record? Good question. Let's talk about that. It depends on your case, particular facts about your case, also how your case is or was handled when it went to court. If you already went to court, if you were convicted of DUI, okay, in Mississippi, you were convicted of a DUI, let's say you pled guilty to it some time ago, and you're wondering, how long is this going to be on my record? Can I get it off my record? Maybe. You might be able to. There is a provision in the law that says that if you've been convicted of a first time a DUI in Mississippi, you can apply to have it taken off your record 5 years after the end of your sentence. 5 years from the expiration of your sentence, you can go back to court, back to the court where you had your case, and ask the judge to take it off your record. You have to have completed all the terms and requirements of your sentence. You have to have paid all your costs and fines, successfully completed probation, taken whatever classes you need to take. All right. Now, this isn't available for everybody, but the minimum requirements are what I just described. You got to wait the 5 years and do everything that you were asked to do. So if you've pled guilty to DUI in the past, that may be an option. All right. What if you have a pending DUI? What if you've just been arrested for drunk driving in Mississippi and you're wondering, gosh, is this going to go on my record? How long is this going to stay on my record? All right. There's basically, if you want to have a chance of keeping it off your record, this is the way. There are two options here. One, you can go through a process called non-adjudication. I'll talk about that more in a minute. Or you can have a trial. You can maintain your innocence and make the state prove its case against you, put its proof in front of a judge, or in some cases in front of a jury, and try to beat the case that way, an acquittal. All right, you're found not guilty. If you're found not guilty, then it's dismissed, and you can have that removed from your record. All right, so that's going to trial. That's kind of doing it the hard way, but sometimes that's the only way. Going back to non-adjudication, I have talked about this in videos in the past. There is a wealth of information on the internet about non-adjudication in Mississippi. It's been the law now for about 6 years, and it's really changed things. You know, how certain DUIs, especially first-time DUIs, are handled. Non-adjudication is basically a deferred program for first-time offenders, qualified first-time offenders. It's basically supervised probation for a period of time, and doing certain things. I mean, the things you've got to do in non-adjudication are basically the things that you would have to do if you were convicted. If you pled guilty under the old way of doing it, you still have to do those things, the probation classes, paying your court costs and fines. All right. At the end of all that, if you qualify for non-adjudication, and not everybody will, but if you do, and you set it up that way on the front end, at the end of your probation, and after you've paid everything and done everything you're supposed to do, you can go back to court, and the charge will be dismissed, and then you can have it expunged from your record. All right, so those are the ways. If you've got an old case in which you pled guilty, you may be able to go back and petition the court to have it off your record. If you've got a current case, then if you want any chance of keeping it off your record, you've either got to go to trial and beat it, or if you qualify, you can go through that non-adjudication program. That, in a nutshell, is how you can get a DUI off your record in the state of Mississippi.